Hi, Max here with FrizWoods, and I want to take an opportunity in this video to talk to you a little bit about self-defense. Self-defense seems to be a very polarizing issue, and states all treat it differently. Whether you're in the state of Florida, where you may have a defense like stand your ground, entitled to a pre-trial constitutional hearing on something like deadly force, and then you have states like Maryland, which have given you a duty to retreat, doesn't allow deadly force in some situations. So, first of all, self defense kind of belongs in two different baskets here. We have self defense, which does not involve deadly force, and then we have self defense as a defense to cases involving deadly force. We're talking about homicides and murder charges and things like that. Let's talk about things in the first basket first. Self defense that does not involve a death. Okay. So, in typical self defense scenarios, a duty to retreat applies. What we're talking about here is defense of property, defense of others, or defense of oneself. In the context of typical self-defense, deadly force is not authorized unless you meet a certain burden, a certain threshold level of threat, and you may have a duty to retreat. There are limited scenarios where you do not have a duty to retreat. Okay, and the first and most common one that we talk about is inside of your own home. We call that the castle doctrine. Okay, a person does not have a duty to retreat inside of their own home. However, they may have a duty to retreat if they're out on the street. The duty to retreat might not apply if retreating would put you in more danger. So turning your back on an imminent threat might put you in more danger than, I don't know, standing your ground and fighting them. If you don't know safe escape routes, say you're in an unknown area, right? It's late at night, you don't know where you are, you may not have a duty to retreat because you may not know where you're going. If you're being robbed, or if you're lawfully detaining somebody, like if you're a police officer. Now, if you, through your attorney, generate self defense as a defense, we then need to talk about what would happen in a trial, because that's where self defense or defense of others or defense of property comes up. So, generating the defense happens through either your testimony or cross examination of your attorney. Once it's been generated as an issue, then we would look at something like a jury instruction to see how a fact finder would basically weigh the defense of self defense. The reason is it's a factual issue whether or not self defense should bar the prosecution. And again, we're not talking deadly force yet. We're talking run of the mill typical self defense cases. The first thing we would look at is whether or not you were the aggressor. And if you were the aggressor, whether or not you raised the fight to a higher level, more so for deadly force. Whether or not you believed you were in imminent danger of bodily harm, whether that belief was reasonable, and whether or not your response was proportional. You used no more force than reasonably necessary to defend yourself. So when we look at proportionality, I might use some examples here, some hypotheticals. If somebody flicks you in the ear and you decide to shoot them in the foot, it's probably disproportionate, right? This and a gunshot to the foot are not on equal grounds in terms of the level of damage you're causing the other person versus the threat. Proportionate response might be more like the example of you get punched in the face by somebody outside of a bar and you punch them back, and then you're charged with assault. You would probably win on prompt four at least, at a minimum there, with regards to whether or not that's proportional. I mean, if you're punched and you punch back, that's probably proportional. Now, if you punch back 19 times while the person's unconscious, might be disproportionate in response to a single punch, okay? So it's not like punch for punch is automatically proportional. Now, if in fact you're in a non deadly force scenario and you meet those four factors, it becomes the state's obligation in order to convince a jury or a judge to convict you to prove that one of those things isn't true. And if they can't do that, then it's a not guilty. Okay, it's a defense. But in the realm of deadly force, it's a little bit different. In the realm of deadly force, we're typically talking about cases involving first degree premeditated murder or second degree specific intent murder. And there, perfect versus imperfect self defense comes into play. So often in shooting cases, for example, a person might claim they shot at me first, and there might even be evidence of that. And then it shifts from away from an absolute defense to perhaps it invokes some version of partial self-defense or imperfect self-defense. And those are entirely fact-specific and also charge-specific. It'd be very hard in a short video like this to explain to you imperfect self-defense and voluntary manslaughter and complicated legal concepts in these homicide cases. However, it is not always an absolute bar. It doesn't automatically mean a not guilty in a murder case if, in fact, you are raising the defense of self-defense. There's a very specific set of instructions related to imperfect and perfect self-defense in the realm of manslaughter and murder. But most of the time when I receive questions about self-defense, we're generally talking about assault cases, misdemeanors, some felony cases. But when you're talking self-defense, for the most part, it is a full defense to almost all charges besides those murder charges I talked about. And it's a burden-shifting exercise, meaning once you raise it, it becomes the state's job to disprove it. Now, if you're worried, you're in Maryland, and you're thinking, if somebody breaks in my house at night, can I in fact use deadly force? And the answer is yes, we do have what's called the Castle Doctrine in Maryland, but there is an actual instruction on self defense related to defense of habitation. And in that particular defense, it may come at issue whether or not the person was breaking and entering into your home. You cannot use deadly force to defend your property, right? If somebody steals your backpack, you can't shoot them. However, if somebody's breaking and entering into your home, you may have the ability to use deadly force. And what we look at here is a different jury instruction on defense of habitation. So this particular instruction would actually ask a jury to analyze whether or not the person who you killed entering your home attempted to enter your home, whether you believe they intended to commit a crime that would involve imminent threat of death or serious bodily harm, whether you reasonably believe they intended to commit the crime, whether you believe the force was necessary to prevent it, imminent death to themselves, and whether they believe the force was necessary. Sorry if that's a duplicate there. So, in order to convict a person who killed somebody who broke into a defendant's home, the state would have to show that that doesn't apply by proving beyond a reasonable doubt at least one of the 5 factors was absent. And the same goes for self-defense. They would have to prove beyond a reasonable doubt one of those 4 factors is absent. So, the burden shifts to the state, and the burden of proof is the same for beyond a reasonable doubt. Self-defense is a really case-specific sort of exercise and defense in a criminal case. So if you've got a criminal case and you're sitting there trying to figure out, can I use self-defense or not, it's probably important to talk to an attorney. An attorney is going to be able to analyze your specific facts of your case and give you the answer to the question that you might be sitting here listening to this video wondering, which is, can I claim self-defense or not? So what I think is important, if you get nothing else from this video, if you want to know more about self-defense as it applies to your criminal case, you should call an attorney. In my firm, FrizWoods, we have a 24-hour attorney consultation line. We're licensed to practice in the state of Maryland, and we'd be happy to chat with you about your case. Now, if your case is in another state and you're watching this video, it probably doesn't apply because it's likely that your state has different laws as it pertains to self-defense. So if you're charged in another state, again, I recommend you talk with an attorney in your state. If you're charged in the state of Maryland, we'd be happy to talk about how self-defense might apply in your case. Good luck.